nationally recognized for his contributions to arbitration, construction law, and alternative dispute resolution. He is the founding president of the Asian Institute of Alternative Dispute Resolution and has served twice as director of the Asian International Arbitration Center. With over 3 decades of experience, the Taxandra has acted as presiding arbitrator, co-arbitrator, and sole arbitrator in more than 300 domestic and international arbitrations under various institutional and ad hoc rules. His academic background spans law, architecture, urban planning, and construction, making him a rare polymath in the legal and built environment sections. He has authored numerous leading texts on arbitration and construction law and held academic positions and institutions in Malaysia, India, and China. For his services, he was conferred the federal title of the Tag by the King of Malaysia in 2012 and was named the 2023 leading international arbitrator by APCAM. Let us welcome the Taxandra, and he will begin today's discussion.
Thank you, Alan. I thought you're not going to stop. So the webinar would have been over by the time you finish. Thank you very much. Very warm introduction. I truly appreciate that you have set the stage for today's discussion. And it's wonderful to see so many of you all joining us today. We have about 30 people now with us. And then good morning, everyone. And welcome to our webinar, Beyond the Games, Rules, Mediation and Arbitration in International Sports. As Alan has introduced me, I'm Sundra Raju, and I'm delighted to be your moderator for today's session. It is an exciting opportunity for us to explore how disputes in the world of sports are resolved and to hear directly from our experts who are here, who have the experience in this area. I'm very fortunate. In fact, I'm delighted that we have with us an outstanding panel of experts. And let me introduce them briefly. First, we have Mr. Alexandre Maciel. Alexandre is a lawyer since 2004 with extensive experience in both domestic and international arbitration. He has acted as counsel, sole arbitrator, co-arbitrator, and presiding arbitrator, and is a member of several national and international arbitration panels. He's a fellow of the Chartered Institute of Arbitrators and AKICA, which is the Australian Institute, and also a certified arbitrator with AIADR. Next, we have my friend, Ms. Samrit Kaur, who's an advocate and solicitor, and she is managing partner of Mrs. Samrit Sanjeev and Partners in Kuala Lumpur. She holds an LLB from the University of Coventry and a certificate of legal practice and an LLM from the University of Malaya, which specializing in alternative dispute resolution. She is a certified mediator and serves as arbitrator, mediator, and adjudicator with multiple organizations, including AIADR, CIDRAC, SIAC, the Thai Arbitration Institute, the Thai Arbitration Center, the Brunei Arbitration Center, and BCAM. BCAM is the Borneo Center, Arbitration Center. She also serves as a domain name dispute resolution panelist. There are not many. I can tell you that because I used to appoint her when I was in AIAC. And she is also on the Asian Domain Name Dispute Resolution Center in Hong Kong. Now, finally, and not last, but not least, is that we have Mr. Victor Wong Rongze, who is a subcommittee member of the Sports Law Association of Malaysia, SLAM, and is currently attached to Chai and Associates. Victor holds a Bachelor of Law degrees from the Multimedia University, where he served as a peer tutor for sports law. His professional focus is on alternative dispute resolution, particularly mediation and arbitration in international sports, disputes and on promoting effective ADR mechanisms in the sports arena. Now, today's discussion, we are going to focus on three main areas, which I will describe now, which is actually central to our understanding of what sports disputes are and how they should be resolved. So the first focus area is what happens when things go wrong in sports. And we will look at, the panel itself will look at the immediate impact on athlete teams and federations when a dispute arises, including urgent issues like selection controversies and safeguarding complaints. The second focus area is we are going to look at hot issues. What are the hot issues and emerging trends in sports disputes? We will discuss current challenges, such as balancing the integrity of the game, ethnic rights and commercial interests, as well as the new AI, which is the buzzword, assisted officiating, and the role of human rights in sports. Then the third focus will be inside the process itself, looking at how sports mediation and arbitration really work. We will explore how sports arbitration and mediation offer and differ from regular court proceedings and what the parties should know when agreeing to arbitration, when mediation works best, and the limits of where the court system in sports disputes are. So I would like to highlight in today's session, and we will have a free flow discussion format. This means that our panelists will respond directly to the questions raised by me, allowing for a more dynamic kind of approach, interactive, I hope. And then at the end of the session, we will have a question and answer, which will be open to all of you all in the audience. And please feel free to submit your questions through the chat box throughout this webinar. Now, our goal is to go beyond the rules of the game while we provide a clear picture of how disputes are actually handled and the vital role that ADR methods, including mediation and arbitration, does in keeping the ecosystem, I think, one, fair and also efficient. Without much ado, I will now kick off today's discussion. And the first question that I have, I will direct it to Victor. Victor, when a dispute arises in sport, what are the immediate consequences for the athletes? That's one. For the teams or the federation if the dispute is not resolved quickly?
Yes, thank you, Doctor, for the question. And I'm Victor from China Associates and as well as SLAM. So for this question, right, in sports, for me, time is not just money in the sports industry, but time is as well the opportunity, the eligibility to play matches, to play the tournaments. So when a dispute is not resolved quickly, the consequences can be immediate and sometimes irreversible, because when sanctions happen, we cannot replay the match, as we know. So for athletes, right, the delay can mean the loss of career opportunities for sure, which we all know that an athlete's career is indeed very short. So missing a competition itself is not like missing a meeting. Okay, it can mean like losing ranks, losing points, and even sponsorship exposures or qualification for a major event. Okay, so the example that I can provide is, like I mentioned, the eligibility issue, okay, before a major tournament. So if an athlete is wrongly excluded in this tournament and the issue is not resolved before the match begins, even a later favorable decision after the match cannot restore the opportunity lost. So let's say you cannot replay the Olympics or reschedule a World Cup, right? And similarly in major issues like doping cases, right? The prolonged proceedings can sometimes severely damage the reputation of the athletes. And even before a final decision is made, the athletes may also face provisional suspension already, media scrutiny, and even withdrawal of sponsors. So the longer the uncertainty continues, the greater the reputational harm, regardless of eventual outcome would occur. And secondly, I can say from the aspects of teams and clubs, because we consider transfer disputes during a transfer window, right? For instance of football law. And if a dispute over contractual termination or registration is unresolved, a player can then be unable to compete. And that would definitely affect the team performance, league standings, and even relegation risk. Then the third aspect would be on federations and governing bodies on the impacts. This aspect, it would sometimes delay and undermines the integrity and credibility for the governing body itself, all right? Because in sports arena, it operates on fixed calendars. As we know, the matches are fixed on particular dates. So if disputes over competition results, disciplinary sanctions or governance issues will linger unresolved, and the legitimacy itself of the competition can also be questioned from the governing body standalone. And take example of match fixing or let's say disciplinary investigation examples from the governing bodies. If the sanctions are delayed or the so-called sanctions are questioned, the integrity of the competition would also be questioned by the public, especially from the fans, the sponsors, and broadcaster may lose confidence in the federation and governing bodies. And also in high-level sports, the credibility is indeed everything. And yes, if the proceedings, the outcomes or sanctions are delayed, okay, justice are delayed for sure. So the consequences are threefold. From athletes, it's loss of competitive opportunity. For teams, it's definitely the financial instability or sporting instability. And for governing bodies, it's definitely the integrity risk. So the speed in sports is not simply procedural efficiency. It is indeed essential to preserving fairness, commercial value. That's from me, Dato'.
Right. Thank you, Victor. It just suggests that it becomes quite complex when you actually have a dispute. The consequences are far-reaching, or both on the athlete and both on the teams, and then there is also an issue of money, commercial issues, that basically will be affected. And then, of course, the sport itself, the tarnishing of the sport, the integrity of the sport. Coming back to Samrit. Samrit, actually we are on the matter of dispute. And let's say a dispute actually erupts in mid-competition. And what should take priority? Whether the integrity of the game should take priority, or the athlete's rights, or should it be the commercial interest? And then I think the real question is that who decides which takes priority? Can you advise us what is the position that you think it is?
Thank you, Doctor, for the question. And good morning, good afternoon, good evening, everyone, wherever you are. I'll dive into the question. So when a dispute erupts mid-competition, the instinct actually is to rank the priorities. And firstly, it's the integrity of the game. Second comes athletic rights, and followed by commercial interest. So that is how it's usually ranked. But in reality, these are interdependent because evidently, if athletic rights are ignored, integrity suffers. If integrity collapses, then commercial value collapses. And if commercial pressure dominates, legitimacy becomes is questioned. So maybe we should not be ranking them in priorities, but rather seeing how to balance them in real time and without undermining legitimacy. So the reason why mid-competition disputes are uniquely volatile is due to the fact that decisions must be made immediately. We see that in sports competition everywhere that, you know, the decision come within hours sometimes. So the stakes, the stakes are reputational, financial, and career defining, and the outcome can alter. We have seen this again, you know, alter medals, titles, sponsorships, and public trust. So this is why bodies like the Court of Arbitration for Sports, in which we usually say CAS, operates as an ad hoc division during Olympic Games, for example, to deliver decision within 24 hours. So bear in mind that although speed protects competition integrity, it should never erase fairness. So again, it's a balancing act. So with regards to the athlete rights, one may argue that it should always be non-negotiable because athletes are not just participants, they are right holders. When I say right holders, this include entitlement to, you know, they must have access to natural justice, due process, that means going through a fair trial and transparent procedure. They must have the right to be heard. The proportionality of the sanctions, the punishment must be proportionate to the wrongdoing, and there must be equality and non-discrimination. The World Anti-Doping Agency, WADA, the WADA Code, for example, embeds these procedural safeguards even in expedited hearings. So there is something that we can rely on to make sure that, you know, everything, the procedure is fair. So if an athlete is excluded without due process, the results may stand, but the system loses moral authority. So athlete rights are not just secondary, but the foundation, I would say, the foundation of legitimacy, and equally important to stand tall. Now, the third one we talk about, how about the commercial interest? We often hear commercial interest is the silent but powerful stakeholder. Why do we say that? It is because broadcasters, sponsors, event organizers invest billions. No, you know, we don't talk about millions anymore, but billions into events such as Olympic Games, the World Cup, Grand Slam, and big competition. So they require certainty that the game will go on. So if there is any mid-competition dispute, although one may not notice, or even acknowledge openly, these sports sponsors do exert pressure for swift resolution, because delay or cancellation may cost millions, and uncertainty will disrupt programming and stakeholders' confidence. So if there is a last-minute injunction stopping a final, it will affect not just the media rights, but also the sponsorship exposure, ticketing, and reputation. So having said that, the commercial interest cannot detect the outcome of dispute, but only the process management. So in other words, I would say that it cannot allow the interest to corrupt the method, procedure, and fairness of the decision-making process. Now, back to your second question, who gets to decide? Well, ultimately, the governing bodies make the first instance decision. So it's the governing body makes the first instance regulatory decisions. Then the independent tribunal and arbitral panel reviews them. And in international sports, the final authority is CAS. It is the recognized adjudicative authority under the sports regulatory framework. So to sum this all up, I would say legitimacy takes priority, as it is the condition that makes integrity, athlete rights, and commercial interests sustainable. That's all from me.
Oh, it's a very comprehensive answer. You know, one thing that we realize that everybody wants speed. They want to make it quickly, decided quickly. they run as fast as they can, and then the disputes also need to be done fast. And I suppose, on the other hand, as you said, there's a big money involved. For example, I was in FIFA, and I still remember the amount of money that we were talking about was so large, and the sponsorship requirements are so large, and the various federations were dependent on this kind of money coming in, that sometimes it started to create unbearable pressure on a lot of things. And I think, as a follow-up question, I think it's very, very important now to, there's an assumption that somehow other sports arbitration is a faster version than court litigation. And but in reality, how does the process, you did allude to sports tribunal, how does the process before such tribunals, and including that set up by CAS, which is the Court of Arbitration Sports, actually differ in structure, procedure, and perhaps even the advocacy style that is done? How can you comment on that?
Yeah, sure. So let's start with correcting the misconception. Many assume that this sports arbitration is simply court litigation on a fast-forward mode. It is not. So proceedings before tribunal like CAS differ not just in the speed, but in structure, procedure, evidentiary flexibility, and even advocacy style and culture. So let's talk about structure. How different is the structure? Firstly, it is a specialized jurisdiction. CAS is not a generalist court. It deals exclusively with just sports. So the panel comprised of arbitrators with expertise in sports regulation, anti-doping, framework, selection disputes, and governance rule. Unlike domestic courts, CAS operate under the Code of Sports Related Arbitration, the regulatory framework of International Federation, the World Anti-Doping Agency Code for doping matters. So all this creates a highly specialized ecosystem, including this ad hoc and expedited divisions. So as mentioned earlier, during Olympic Games, CAS actually established an ad hoc division capable of issuing decision within 24 hours, something ordinary courts simply cannot replicate. So there is also, besides that, then there's a procedural difference in sports arbitration matters. So in sports arbitration, it is less rigid in admitting evidence, more flexible in admissibility, getting confused. And often it's document heavy and frequently conducted on compressed time. So there's no strict application of domestic rules of evidence. So, for example, our Evidence Act will not apply in sports arbitration. The appeal structure is also different. Most cases before CAS appeal, most cases before the CAS are appeals from decisions of International Federation, and these appeals are generally heard divino. What does divino means? That the panel retries the case anew. They review the facts, the law, and the evidence, and are not strictly limited to finding of the previous sporting body. This is fundamentally different from our judicial review in national courts, because where appeals are not meant for retrial, but just review decisions for error of law, fact, or procedure. But here in the appeals in CAS, it's a retrial of the whole thing again. So that's definitely very different. The advocacy style before CAS is also different in tone and in strategy. So it's highly focused on pleadings. It's less theoretical, more technical. The panels are highly familiar with sports regulation, and it's also a more regulated centric, meaning that Arguments revolve around interpretation of federation statutes, proportionality of sanctions, consistency with prior CAS jurisprudence. So the proceeding is also time sensitive and solution orientated. Submissions must be concise and focused, especially on urgent matters. The council must know how to balance legal precision, scientific evidence, especially in doping cases, regulatory interpretation, and practical consequences for the competition. So all these are different. And finally, there is also a cultural difference. When we talk about cultural difference in sports, it's actually about governance. So sports operate in a transnational regulatory system, and CAS, like we said, it acts as a quasi-Supreme Court of sports. So as its decisions are final and set precedent that apply globally, creating harmonization across the jurisdiction. So this means that every decision carried systemic impact, consistency, and advocates in presenting their cases must consider the broader regulatory implication, not just their client's case, but how the ruling will affect the sports as a whole. So in other words, arguing before CAS, it's not just legal advocacy, it's participating in the governance of international sports. To simplify and to sum this all up, sports arbitration is not simply a faster version of court litigation. It is more specialized, more regulatory in character, more flexible procedurally, more compressed in time, and often more international impacted. So it's actually a unique form requiring a distinct mindset from the councils and decision makers alike. That's all.
It's not a mirror image of any other construction arbitration or commercial arbitration. It's different.
It's absolutely different.
Right. Thank you, Samrit. Alexander, we are all arbitrators, and we tend to actually promote arbitration as the way of doing things. I mean, we have a vested interest, I suppose. But is arbitration really the right solution for resolving sports disputes? And basically, I would like to actually hear from you, what would be the potential disadvantages, especially for athletes, as compared to litigation in the courts? Alexander.
Thank you, Professor. It's a pleasure and an honor. Diving directly to the question, I would like to say that there is no miracle solution. There is no miracle solution. In some cases, you can always privilege the arbitration, but regarding the athletes, as you said, Professor, maybe in some cases, you rather prefer to go with the state tribunals. So when you talk about this dichotomy, you must see this milestone in Western countries. That's my experience. As arbitration has become the dominant mechanism for resolving sports disputes. In a large number of countries in Europe, arbitration it's mandatory for a considerable number of issues. So if you want to resolve some kind of problem regarding sports, you don't have the opportunity of the option, better said, to go to the state tribunals. It's mandatory. It's mandatory for both parties, athletes, clubs, associations, and federations, particularly in high performance and international sport. Because as my previous panelists colleagues referred, we are not talking about regional sports, but even regional sport, even some regional or national competitions have an international dimension, because you have clubs, you have athletes that compete in their own country, in their national countries, and they compete abroad. However, I'm an arbitration enthusiastic, and I advocate in my country and in the countries in Europe, as I intervene as a lawyer and as an arbitrator, I think the path should be to grow the number of arbitrational institutions specialized not only in sports but in other matters, but in this case in sports. I rather prefer arbitration than the state tribunals. Although it offers significant advantages that are similar to commercial arbitration, to construction arbitration, to environmental arbitration, such as expertise, speed, uniformity of jurisprudence, and international enforceability, you have also to consider that presents structural and practical disadvantages, especially for athletes. As you mentioned, Professor, athletes, you don't have sports if you don't have athletes. You can have organizations, you can have federations, you can have FIFA, you can have UEFA, you can have the Olympic Committee, you can have the sponsors, you can have the companies, you can have all the billions of dollars, of euros, of libras, whatever. But if you don't have athletes, you don't have income as the product. So, especially for athletes, when comparing arbitration and state courts, in some cases, the athletes, if I was an athlete, or if an athlete seeks my advice, I will say, let's see, in this case, you should go to arbitration. But the rule, you cannot define a rule. Go always to arbitration, go always to state courts. So if you have a specialization and expertise, if you have speed and procedural flexibility, if you have uniformity international coherence, if you have finite and unlimited appeals, it's the great advantages of arbitration. You can also have potential disadvantages for athletes. Questionable voluntariness of consent. As you know, Professor, in the European Court on Human Rights, there are several decisions regarding these matters. You have Adrian Mutu, who was a soccer player, a Romanian soccer player who have promoted a process in the European Court of Human Rights regarding the questions of due process in arbitration, because it considered, the athlete considered that the CAS or the TAS, the Tribunal for Arbitration for Sport, did not fully respected his human rights. And one of the human rights that was in discussion was his consent, involuntary consent, regarding the mandatory regulation of TAS.
So what is the potential disadvantage, Alexandra? That's a point that I wanted to know. When you actually go for arbitration, particularly if you're an athlete, what would the disadvantage be that the athlete could possibly face?
The limited judicial review. You have more opportunities in state courts to review the decisions.
Right.
You have the problem regarding the costs.
Costs. Right.
The costs.
Cost is because it's expensive, is it?
Is expensive, and our focus are in high professional athletes, but you have athletes that are not very well. Their incomes are very low, even in great countries like Germany and in England and France. In some sports, their incomes that are very low, so the costs will be a problem. For example, in Europe, you will pay more in arbitration than in state courts.
Right.
And then there are some disadvantages, like the perceived structural imbalance. The image of arbitration in sports is not consolidated as impartial as transparency. There are a lot of perceived institutional bias,
Institutional bias.
Yes, it's like the wife of the emperor, no? It's not. It's important to be serious, but it's also very, very important to look serious. In arbitration in sports, regarding the context of Europe, there is some perceived institutional bias. And then the transparency concerns regarding this perceived structural imbalance. The athletes always, or not always, but in most cases, they assume that the organizations, the federations, the clubs, and the international institutions like WADA have a bigger power, have a stronger position comparison to athletes. So if I was an athlete, I probably go I will option to the state court with the state court, because I will be more protected.
That's very enlightening, Alexandre. Because we all tend to promote arbitration as the way. But if you stand in certain perspective, as you say, some athletes are not that rich. They may want to have access to the courts, and they want the publicity, perhaps, to actually right a perceived wrong. But I think one of the things that we all know, that arbitration is consensual. Basically, it's arbitration agreements. Arbitration itself is based on the consent of parties. Parties must consent in one form or another. There must be some kind of arbitration agreement. And from a practical viewpoint, Victor, what should parties understand before they enter or agree to an arbitration agreement?
Yes, thank you, Doctor. So from my point of view, first, the parties should understand that not every dispute is indeed arbitrable. Certain matters may engage the so-called aspects of, let's say, public policy or statutory rights that cannot be excluded by the contracts. For instance, let me cite a court case of Esther City and Football Conference. The court in this case refused to stay proceedings because statutory shareholders' rights were considered inalienable and could not be removed through these arbitration agreements. Similarly, in another case of Ecor Suisse, which the court emphasized that arbitral awards must comply with fundamental public policy rules. Thus, the award may face a risk of being invalid if its outcome is against public policy itself. Second point of view, which is on the issue of jurisdiction and validity of the arbitration agreement itself. So if the validity of the arbitration agreement is challenged in the end, this typically raises a question as to the arbitral tribunal's competence in that particular case. And under our let's say so-called arbitration legislation, such as our Malaysian Arbitration Act 2005. The tribunal itself has the power to rule on its own jurisdiction, which is a principle often referred to as competence. So the court here have recognized that arbitration proceedings may take precedence even where jurisdiction is disputed. And last but not least was a point just now slightly mentioned by Alexander, which is the issue of consent. So in the sports context, the challenges sometimes would arise on the basis of perhaps lack of true consent. For instance, arguments that arbitration rule was imposed or contrary to the aspect of human rights principles. And however, the courts have generally upheld the sports arbitration as a legitimate and fair dispute resolution mechanism, as reflected in cases such as Stratford and FA, where human rights challenges ultimately failed. So in summary, right, before agreeing to this arbitration agreement, the parties should understand the scope itself and the limits, perhaps in terms of arbitrability and public policy, whether it's against any existing public policy, and as well as the tribunal's authority to determine its own jurisdiction. So these issues I mentioned would fundamentally shape how any future dispute would be resolved.
Thank you, Victor. It was very interesting. You say that essentially an arbitration, parties must understand that an arbitration agreement creates certain obligations on them. And then it also brings into play certain concepts which are enshrined in the arbitration law. For example, as you talked about competence, the arbitral tribunal can decide its own jurisdiction and can decide many, many things as long as it's in the agreement. Now, Alexandria, I think somebody alluded earlier that sports arbitration is different from commercial arbitration, and assuming that is a fact, it is a fact, and that's the case, should there be provisions specific to sports arbitration in the arbitration law of the country or jurisdiction?
Yes, thank you, Professor, for the question. Again, there are substantial differences between commercial arbitration and sports arbitration. And my answer to your question is affirmative. Should there be provisions specific to sports arbitration national laws? Yes. The premise that sports arbitration is structurally and functionally distinct from commercial arbitration strongly supports the case for specific provision in national laws. Why? Because the matter of consent that you mentioned before, Professor, while both are rooted in party autonomy and the private resolution of disputes, sports arbitration operates within a unique normative and institutional ecosystem that justifies a differentiated regulations. And why? Because we must protect the weakest party regarding arbitration in sports, that is athletes. You have regulatory nature of disputes, you have vertical government structure, you have mandatory arbitration clauses. For me, is the most sensible aspect, because arbitration is frequently imposed as a condition of participation in competitions. Some athletes are forced to go to arbitration to solve their disputes, and because the regulation of their sport activity, the organization, the federation imposes in their regulations that arbitration is mandatory. So these characteristics raise concerns not typically present in commercial arbitration, as you know, Professor, particularly regarding equality of arms, access to justice, and procedural fairness. Why? Because that I go back some minutes ago to the question of the image. The athletes feel they feel when they go to arbitration, there is no equality of arms, no access to justice, and procedural fairness. So the only way to solve this problem is to introduce in national laws specific provision to sports arbitration. Why? To protection the weaker parties, the athletes, to protect public interest and constitutional concerns, because sports arbitration frequently intersects with fundamental rights, the right to work, the right to a due process, and a right to effective judicial protection. So, if you protect the athletes, you protect the integrity of sport. Like some is referred previously, is fundamental to guarantee the integrity of sport. Some opponents of specific regulations regarding sports argue that, oh, general arbitration law already provides sufficient safeguards. If you have excessive national regulation, could undermine international harmonization. If every country regulates, you will not have international harmonization. You will not be contributing to the lex sportiva, like the lex mercatoria. You will not have a lex sportiva. But in conclusion, in my opinion, and regarding my experience, I think that it's very important by ordinary law reasons, but mostly constitutional reasons, to include specific provisions for sports arbitration in national laws. You rather prefer a system with strength procedural safeguards that protects athletes as structurally weaker parties, because you will ensure compatibility with constitutional and human rights standards. You can maintain international harmonization, but you also have protect, as I mentioned before, your products. And your products, in this case, are the athletes. So we must have, in my opinion, specific provisions for sports arbitration in national laws. Thank you, Professor.
That actually leads up to a follow-up question. In Portugal, where you come from, is sports arbitration mandatory or voluntary? Is there a specific law that says that you must, when it comes to sports arbitration, you must actually go to where sports is involved, or certain aspects or certain kinds of sports are involved, that if you have a dispute, you must go to arbitration? Is there such a provision in Portugal?
Yes, Professor. Thank you for your question. When you talk about Portugal, you can find two scenarios. The first scenario, you don't have any regulation. And the second scenario, when you have regulation, you don't have a regulation to one side. You have a regulation that is a balance. So in Portugal, sports arbitration under national legal framework of our country can be either mandatory, compulsory, or voluntary. We have the two options. Or let me rephrase. We have the two solutions. There are two solutions that can combine three options. You have mandatory, compulsory sports arbitration for all the parties. No one can discuss. In some matters, you must go to arbitration. You cannot choose. In some other cases, the second option, it's mandatory for the organizations and for the federations, for the institution that organize or regulate sports in Portugal. But the athletes can make the option to go to arbitration of state courts. And the third option is the voluntary arbitration. But since 2013, we have a law that created a sports arbitration tribunal. The Portuguese Sports Arbitration Tribunal was created at the image of CAS. We have our little CAS. We have our little CAS. But as always, in Portugal, our Portuguese Sports Arbitration Tribunal has two chambers. The first chamber and an appeal chamber. If you go to the appeal chamber to appeal from the decisions, the arbitral awards of first instance, you cannot go to the state courts. You can go, but only in limited situations. If you don't go to the chamber of appeal, you can appeal to the state courts. This kind of mixed solutions is not, for me, the perfect scenario, because in many cases the arbitral proceedings extends in time much farther than what is recommended. And when you appeal to the state courts, you can spend a large amount of time. The city where I was born, our soccer club, is struggling for the last 20 years in state courts regarding in the previous phase discussing the promotion to the third division, and in the second phase in the last 8 years discussing the amount of the compensation regarding that the promotion. So in Portugal, in conclusion, arbitration is mandatory, compulsory in some cases, and voluntary in other cases. We have a Portuguese Sports Arbitration Tribunal at the image of CAS.
I think one of the interesting things that I've been watching around the world is that many jurisdictions are trying very hard to create specialized sports arbitration, sports dispute resolution mechanisms, either by way of the Arbitration Act or by specialized rules, or even they may even set up a tribunal, which is basically an administrative tribunal. But there is actually this feeling of trying to deal with it. So Victor, we really come to this thing, you see, of course, we know that we have a legal rule, for example, that if there's an arbitration clause under the ancestral model law, which many countries are part, including Malaysia, I think Portugal and other places, there is a mandatory stay of the court proceedings. No, so to a large extent, an arbitration clause outs the jurisdiction of the court. To what extent, actually, I want to understand, I think it would be very useful to understand the arbitral mechanism itself can exclude the jurisdiction of a national court, Victor?
Yes, thank you, Dr. Perhaps this question is quite beneficial for all those audience, perhaps from sports body, they would like to know the stand, especially in Malaysia, what's the stance? So the short answer from me is yes, indeed, arbitration can limit court intervention to some extent, but however, it cannot completely oust the jurisdiction of our national courts. Perhaps I could enlighten the audience on the local Malaysian law first. And under Section 18 of our Malaysian Own Arbitration Acts, the arbitral tribunal may, the keyword is may, rule on its own jurisdiction. However, this use of the term may does not mean that the courts are entirely excluded from determining jurisdictional questions. And this was made clear, perhaps I could cite one case of Cyber Business Solutions and LSEC Denmark, where the High Court, this case, emphasized that when there are competing arbitration clauses or perhaps disputes about which forum shall prevail, it is ultimately the national courts, but not the arbitral institution. And in other words, I can say arbitration itself cannot self-validate its own jurisdiction without the possibility of any national judicial scrutiny. And as well in sports contexts, the constitutions and roles of federations, sometimes they would like to often attempt to make internal decisions final and binding or to prevent recourse to courts. However, I can see such provisions cannot completely oust the so-called judicial supervision. And I could also cite one relevant case of Enderby Town Football Club and Football Association, where Lord Denning, in this case, observed that although the rules of association are treated in legal theory as a contract itself, but they are in reality a regulatory code only, as they still remain subject to control of the so-called national courts. And any rule that seeks to prevent legal proceedings, such as requiring prior consent before going to courts, shall be contrary to public policy and therefore shall be deemed invalid. And there's, however, another case of Baker and Jones. Perhaps the courts accepted that association may give the tribunal final authority over factual determinations only, which is the question of facts only, but not question of law, right? Since it cannot exclude the roles of the courts in reviewing question of law, as the courts retain a supervisionary jurisdiction itself, particularly in order to ensure compliance with the most important principle of natural justice. So in short, I can conclude that the sport arbitration itself can validly require disputes to be referred to itself and to limit parallel courts proceedings and provide that awards to some certain extents shall be final and binding. However, in contrast, it shall not completely exclude judicial review and shall not prevent courts from determining any question of law, any jurisdictional challenges, or to avoid scrutiny on grounds on public policy, natural justice, or legality. So ultimately, the arbitration does not replace the courts. It shall operate within a framework where the court exercises a so-called supervisionary role. Thank you.
Yeah, thank you, Victor. But one thing that is coming across from the discussion we've been having is that there's a suggestion that arbitration, which is rights-based, mimics the court system, tries to actually take some concepts, and it is based on fault finding. And I think there's also, we were talking about expense, they're sometimes more expensive for athletes and all these things. And then perhaps there's a need for specialized frameworks to be set up. But there is actually a general dissatisfaction, as I understand it, in the world with arbitration. It is not only in sports, but it's in general in commercial arbitration, in investment arbitration, and all these things. Everybody is saying, look, arbitration does not seem to be the only method that we should use. Maybe that's a rights-based method. Maybe we should look at something else, like interest-based. And one of the things that is very, very popular now and in great use, and it's actually being translated into legislation, conventions like the Singapore Convention, is mediation. So mediation is my understanding so far. I've been hearing from you all have not mentioned a word of mediation. And what is happening is that, so it does suggest to me that mediation in sports or sports mediation is really underutilized, where when it's compared to arbitration in resolving sports problems. Of course, we have the courts. So I want to ask Samrit, because she's an expert on mediation, writing a book and all these things. So in what types of dispute does mediation genuinely work in international sports? And why would parties hesitate then to use it? You're muted, Samrit. Okay.
Sorry. You are absolutely right, Dato', that we have not touched on mediation, and it is definitely often underutilized, mainly because a lot of people don't understand what mediation is. When you talk about mediation, the first thing, if you ever tell your client, do you want to mediate? The first thing they will question you to say, are you not confident in the case? Because they want to have their day in court, not realizing, the beauty of mediation, where it is you resolving the issues and you coming out with creative solutions at the end of the day, not a third party deciding for you. So having said that, the reason mediation is underutilized is because there are two main misconceptions. One is the belief that the court requires definitive ruling. And secondly, is a perception that mediation signal weaknesses. So you may ask, why is this so? It is actually because in sports, parties just want vindication, not just in sports, I think in most other matters as well, commercial and construction, people just want vindication. They do not want to compromise. So as mentioned earlier, it is crucial to appreciate that not all disputes are suitable for the same ADR mechanism. Some require speed, like sports, some expertise, again, like sports, and others confidentiality, because certain things can be, you don't want the whole world to know, or, to save face. It's best to go into mediation where it is private, confidential, and settlement agreements are confidential. So answering your question, where does mediation work best? There are a few areas that I will highlight. First area, mediation works best in selection, disputes, and eligibility. So where the issue is discretionary rather than rule-based, it works well. So most of the time, team selection conflicts are highly emotional and reputational. So what does mediation do? A mediated solution may then clarify the criteria, whatever they're based on, provide transparent reasoning, agree on development pathway, what is, how to improve the mechanism, and preserve athlete and federation relationship, which is the most important. You do not want to have an issue where you cannot go back to your federation or have a relationship with them. So that is one. The second where mediation works best is in interpersonal and team conflicts. For example, there's a conflict between the athlete and coach. There's a breakdown in that. There's captaincy maybe dispute. Team culture may conflict. Allegations of unfair treatment, maybe on non-disciplinary matters. So why it works in this kind of disputes is because this dispute again are relationship based and ongoing. So arbitration may declare a winner, or courts, when you go to courts, there will be a winner. But in mediation, it can rebuild the trust. It's a win-win for both parties. You never go out of a mediation, a good mediation process and say, I lost. It's always a win-win. So in this aspect, again, because it's relationship-based, it will work best. Third is where mediation works best again in sponsorship and commercial disputes. So any of these type of disputes where there's breakdown between the athlete and the sponsors, the federation and the commercial partners, these are again, relationship-driven and reputational, where mediation then allows for you to end up with a confidential settlement, creative restructuring, and business continuity. And in most Asian culture, we have this face-saving exits. So it is
Saving of face, yeah.
Yeah. So mediation helps that. Fourthly, mediation works also in employment and contractual disputes. For example, coaching contract termination, player transfer disagreements, which Victor mentioned earlier, bonuses or incentive disputes, role renegotiation. So this type of disputes also, I think, is very easily mediated. Fifthly, mediation also works in governance and internal federation conflicts. We have seen even in Malaysia, there are matters that, they have internal conflicts, but court actually treat back down and said that, look, you have mediate, go and mediate before you come back to the court. So this kind of governance and interfederation conflicts includes like boardroom disputes, leadership challenges, AGM, EGM, disciplinary tensions within the federation, disputes, which are often political rather than pure legal. So in this type of disputes, mediation can de-escalate fractional conflicts, avoid public fragmentation, and protect institutional stability. Finally, in a very, very limited scope, and I do not like to say this, but in very limited scope, safeguarding and conduct matters. For example, only in minor interpersonal misconduct, team behavior conflicts, and communication issues, because these are not serious disputes. Serious disputes, you need public accountability and, of course, national sports to come in. So
that's interesting that you should really suggest that some disputes require public scrutiny. Then if that's the case, what are these kind of disputes that require public scrutiny, public kind of accountability? Of course, we have seen recently in Malaysia about the FIFA thing, where the dispute about player selection and fielding. So, if you could actually just continue and tell us what kind of disputes that will require actual public scrutiny and is better to be heard in court.
It would be things like probably what do you call it? Bigger controversy, like where you have really serious misconduct, where there's a breach of what do you call it? Something where you cannot. How do I put it? It is where
I think maybe for example, I'm giving you the recent controversy in Malaysia on player fielding, and then the suggestion that there was actually a misfeasance in not actually fielding players that are not of the nationality or don't meet the nationality, and therefore undercutting the entire game process. And do you think that kind of thing should have been publicly aired, or because it came out as a finding from FIFA, because I think then it just came out into the open. But wouldn't that dispute should not be heard by FIFA or be heard in some other forum?
No, I think because it's a national problem, I think public get involved, and you can't just hide it or push it under the carpet. You need public there has to be accountability and integrity in sports to show everybody that we are on board, we are fair, everything is on board. You cannot, just because it's very sensitive, you want to now have a private arrangement, a private ADR mechanism, so that you don't have to publicize whatever is the outcome is. It is very important to have to have a proper disclosure, because this involves the nation. This involves even the country. Malaysia was put in a bad light because of that. So we need to clear our conscience. We need to clear our slate now.
I think that's one of the arguments about transparency in arbitration. I think for example, in investment arbitrations, the public can actually sit in, they can watch the entire proceedings, because when a finding is found, and if it's adverse to the country, then the taxpayers pay. It involves everybody. So I think they said, okay, this will be an exception to the confidentiality. It came out from the SO case many 20, 30 years ago. So I think the jurisprudence has been developing certain kinds of arbitral proceedings are actually not confidential. I think that's quite interesting. But I think we have to finish soon, so I will finish off with Alexandre. We are now going to one area which is hardly heard in many places, but it's becoming important, particularly the ESG and all these things. To what extent human rights, which is I mean the right to life, the right to play a game, the right to choice, and all these things, those kind of legislation, particularly international conventions and also national legislation, how should it apply to sports, Alexandre? And we'll finish off with that.
Yes, thank you, Professor. I think that human rights in sports arbitration, is one of the hot topics. So, why? Because the transgender question regarding athletes has put some pressure, or a lot of pressure in the not only arbitration but always in state courts, because you have. That's a subject that is very new. It's very different. The approach and treatment and regulation is different all over the world. So yes, I think national and international human rights legislation should apply to sports arbitration, not only as a matter of principle, but increasingly as a part of the movement to have an harmonization of the law, of the international law, as a matter of positive law in the countries. If you regulate in some basis, if you agree that some principles are common to a large number of countries, you can contribute to a larger perspective of human rights legislation regarding arbitration. And why? Because taking, for example, of CAS, the Court of Arbitration for Sport, not so long ago, these matters regarding human rights, they were not very sensitive to them. The right to work, the right to reputation, the property rights, the procedural guarantees were not matters that the CAS views as human rights. So arbitration regarding CAS, it's the experience that I have, and I have studied, I have experienced work as an arbitrator and as a lawyer. I think it exists in a private bubble. Do you understand the expression, Professor? A private bubble. So it's our field. We are immune to these questions. We are not talking about human rights. We are talking about sports. But I cannot understand, how can you imagine sports without human rights? If you look to the Olympic the landmarks of the Olympic Games, if you analyze specifically each one, you will see you are talking about human rights. The right to be a sportsman, to practice sports as an amateur or as a professional, it's a human right. So under the European Convention on Human Rights, the European Court of Human Rights has some decisions that regarding athletes that have promoted process in the European Court of Human Rights because they were not happy. They did not be satisfied with the arbitral awards of CAS because they think, and the European Court of Human Rights recognize their reasons, that arbitration, it's immune in large number of aspects regarding human rights. So you must, in my opinion, we must make an effort in national laws, international laws, and in institutional regarding sports arbitration to provide them as mandatory the application of the legislation regarding human rights. In Europe, of course, the European Convention on Human Rights. Because if you do so, you reduce substantially the image, the negative image that you mentioned, Professor, not only in sports but in commercial arbitration, investment arbitration, technology arbitration, mining, environment. There is a suspicion that there is some suspicion regarding arbitration. And one of the reasons in sports why arbitration has been questioned is the matter of human rights. You cannot protect sports, you cannot respect sports if you don't consider sports as a human rights activity. You cannot see sports as a private activity. You practice sports, and sports is regulated by the national laws, international laws, because there is an interest, public interest in that activity. As Samit said regarding the accountability, the publicity, you cannot have legitimacy and integrity in sports if you don't accountability, if you don't have publicity, and if you don't respect human rights. For example, I don't want to be extended in this matter, but regarding transgender, of course, you can change your perspective of your gender. But if you are a man and you assume as a woman, it's fine to me, and in the Western world, it's fine, no problem. In Europe, we don't have a problem with that. Of course, there are some exceptions, but in larger countries. But if a man assumes himself as a woman, he can be in his private life regarding sports. He cannot compete. He cannot compete as a woman being a man. You cannot change nature. You can change the perspective that you have from nature, but you cannot change completely the nature. So if you, in sports arbitration, if you don't consider the human rights question subject, mostly that men are not women, even though they assume as one, you are not protecting human rights, and you are destroying the very principle, the most important principle in sports. That's equality. In every sports, in every competition, they all start at the same time, in the same conditions. You don't put a young player with 10 years old competing with one with 15 years old. Why? Because the nature is different. And I would like to say this, Professor. You may think it's strange, but in the Western world that I live, there are some persons with importance and power in sports that in this time they're discussing the possibility of the race can be a factor to separate persons in sport. For example, in the marathons and half marathons, it's obvious that African athletes, because of their nature and their preparation and the countries they live, they have more probabilities to have success. So you have people in Europe discussing if you should create competitions, marathons for Africans and marathons for non-Africans.
I think it's a good point to stop, Alexandre. You know why?
Yes.
Because we are already 30 minutes.
Sorry for the extension, but I think.
Okay. Yeah. No.
Sorry,
I accept that. It's a good thing. Maybe let me see whether there's any questions in the chat box. There's none. I must. There is one.
There are two questions.
There's no questions. I don't see any questions. There's one question. Where is that?
There are two.
I didn't see any.
Yes, there are two, Professor.
Let me just
regarding cost of arbitration and the other.
Right. Okay. If sports arbitration is made mandatory by way of legislation, what would be the apt solution of a poor athlete who can't afford arbitration, and would an ombudsman scheme for sports be more practical? That's one question. The second, would you agree that mediation works when both parties are serious to resolve the problem? It is based on give and take. If that fails, the mediator cannot make a decision and to be seen to take sides. In your experience, have you mediated a sports dispute successfully? I think let's start off with the first question. Who wants to take that first? How do we deal with poor athletes who cannot afford arbitration? I think that's basically, anybody wants to do that?
I would agree to the suggestion, have an ombudsman scheme, because it's similar to how the banks have an ombudsman scheme. Have something like that. That will work. That's my one sentence answer.
Yeah, any other ideas?
Yes,
Yes, so please.
I
thought, one thing that last time I remember is that for poor athletes, that the system is subsidized. So basically, it's that you have a situation if an athlete brings a selection dispute, and first thing is that the selection dispute, the arbitrators be paid very little, but they still have to upkeep their thing, and then all the facilities and all these things be provided free. So that you have a quick system. That means it will be the organization or the state carrying the entire thing and vetting whether that dispute is actually real. That's one way. Any other views you all have? Ombudsman, another one is a subsidized method. Any other way? Yes.
Professor, in Portugal, the system subsidizes the athlete if he wants to go to arbitration or to the state courts regarding the subject. But the problem for me is not national, is international. If a poor athlete or a poor club or a poor organization wants to make a case in CAS, the state will not subsidize.
Right. Okay.
So
I think that's fair enough. That's fair enough. Okay. Next one. Mediation will only work if both parties want to make it work. And then if it fails, the mediator cannot make a decision, which is a fact, unless if it's between an evaluative and facilitative method. But I think the question is really, has anyone on the panel successfully mediated sports dispute? If anyone or anybody knows of any experience of sports dispute successfully mediated?
I have some experience, and previously I actually am doing one which I can't name. Hopefully it will be resolved, but to say that the mediator cannot make a decision, it's not the mediator, you're absolutely right, unless it's evaluative mediation. And usually we try not to do evaluative mediation, more facilitating, because it gives comfort to both parties. Otherwise, they would think that why would they believe you or evaluate it when they can go to court? So
right. Okay.
Yeah.
I think that, thank you so much. I think we have to stop here. It's already well past the time. Thank you so much, Victor, Samrit, and Alexandre. It's a wonderful webinar. I learned something, which is very useful for me, and my thought processes are becoming clearer. I hope our audience also enjoyed it. We will meet you all again the next time. Thank you so much again. Goodbye.
thank you.
thank you.
It was a pleasure. Thank you.
Alex,
Yeah,
and
okay.
thank
See you
you.
all then.
Thank
Bye-bye.
you so much.
Samir,
Okay.
Professor.
Bye. Yeah.